Welcome, everyone, to today's webinar. My name is Emma Goodman, and I'm with Becker's Healthcare. And I'm pleased to turn the floor over to Scott Becker, publisher of Becker's Healthcare, and his team from McGuire Woods to start off today's webinar.
Great. Emma, thank you very much. There's three of us on the phone today. We've got partner Jeff Clark, who handles litigation for surgery centers and surgery center chains nationally. Tom Stallings, who's a partner who's got one of the foremost national reputations in peer review issues and credentialing issues and all kinds of issues and disputes related to medical staff bylaws. We're really going to cover three things today. I'll start the first 5 to 10 minutes and speak about core types of litigation and sort of take-home points of advice that we want everybody to have and litigation affecting ASCs. Jeff Clark will then speak for the next 10 minutes or so on observations, thoughts, advice, things that he's seen in surgery center and related litigation. And then finally, Tom Stallings will finish the core of the program with the discussion on peer review, medical staff issues, and some of the issues that he sees there. We also open for questions at any time. I think there's a way to type in questions. We have a great audience of actual surgery centers on the phone, so we'll hope to make this relevant to you. And we'd like at any time, plug in a question, and we'll try and make sure that we cover it today. And thank you. So let me get started. I'm going to start by talking about the kinds of litigation we see. It's a very busy time in litigation for surgery centers, and I'll sort of look at 5 to 7 types of litigation. And you could stay on this slide, Emma. That's absolutely fine. I mean, the first thing that we see is we always are handling cases relating to redemptions of shares where somebody's asserting for one reason or another that they've been redeemed improperly or didn't follow the operating agreement or some kind of case related to redemption of shares. And those could bring into it elements of safe harbor, elements of how somebody's being paid, elements of it's being done consistent with the operating agreement or consistent with just general kickback laws and so forth. So we're always seeing cases on that. It's probably the single area that more litigation revolves around than any other area is that issue. And it no great surprise. A surgery center investment, at least traditionally, was often a physician's best investment he or she ever made compared to the rest of his or her portfolio. It's done fantastically well. He or she has told his spouse for 100 years how well he's done with his ASC investment, and thus when somebody wants to take it away from them, they try and hold on to it and fight that, regardless of what the operating agreement says. But probably the single place we see the most litigation. Next area of litigation, and still common, but was probably much more common 5, 10 years ago when there's so much new building going on in surgery centers, is non-competition agreements. And we still see a decent amount of them, but not as many as we see of redemption cases. And this would be a situation where a physician decides he wants to invest in a different surgery center or wants to open up, he or she wants to open an in-office surgery center or something similar. Some of the non-compete cases today, as compared to 10 years ago, also revolve around a physician who was an owner in a surgery center who had a covenant that said he or she can't be employed, have a management agreement, a medical director agreement, or an ownership interest in something that competes with the surgery center. And if hospitals have ramped up their efforts to employ physicians, some of the non-compete cases involve that as well. The next set of cases that we see in surgery centers after redemptions and non-competes are cases that one way or another bring into play the false claims statute. False claims cases are brought typically by an individual, administrator at the center, an employee at the center, a doctor at the center, a competitor who is looking to the false claims case to turn a case into something where they can get a contingency return by bringing this suit on behalf of the government. And you've seen false claims cases in the surgery center area around several different areas. One false claims case dealt with, it tied into both redemption and sale of shares, but the argument or allegation was that a company and surgery center was selling shares at below fair market value to physicians, and that was a kickback that led to a false claims case. In that case, good news, for the parties is the government chooses not to intervene in it. Bad news is the center and related parties ended up settling that case for several $1 million, I think $3.2 million plus attorney's fees, so ended up being about a $5 million settlement. That again dealt with the sale of shares and different things that went on with the sale of shares. In a related industry, the dialysis industry, one of the large dialysis companies ended up settling a case related to the sale of shares at below fair market value for something like $390 million. Obviously a big case, a whole chain, not a single facility, and different lessons from that case as well. Other areas that we see that lead to false claims case, the obvious traditional ones are things like unneeded surgery or billing fraud or billing impropriety. One of the core pieces of advice I'm going to come back to in a few minutes when I lay out 5 to 7 core pieces of advice is to never panic. The worst situations come from often not doing the misdeed itself, but the efforts to then cover it up. I was on the phone with somebody recently who talked about a big settlement they had and are now worried about a different settlement in a different investigation where the government's taking the computers and so forth. But one of the things that happened was when they originally got a request on lab tests not being correct, they went back in and changed and improved the records. And what it looks like to an investigator is that you're purposely changing it to try and hide conduct. And so one of the things that happens is when you do end up in a situation, you get an allegation, absolutely you do an internal investigation, absolutely you do an internal review, but at that point you're preserving records versus changing records. And it happens often out of good intent, but somebody panics. So false claims cases, billing fraud, unnecessary surgery, sale of shares, particularly at below fair market value. And then there's a new false claims case that the Florida Society of Anesthesia brought against several surgery centers. And this relates to, surgery centers making efforts to take the profits from anesthesia. And the efforts to take the profits from anesthesia are all over the board, from ones that would likely be considered quite legal to ones that are much more aggressive. The allegations in some of these cases are that the surgeon went to the anesthesia group and said, you could keep the anesthesia revenues as long as you give us a piece of them. So and that obviously was something that wouldn't be, depending on facts and circumstances, might be hard to defend, depending on, again, the facts and circumstances. But the more you're operating anesthesia as a true operating part of the center for good reasons, you couldn't otherwise get good coverage, or there could be a whole variety of reasons, the easier it might be to defend. The more that you've gone to your anesthesiologist, more like the sort of a mafia, and said to your anesthesiologist, give us a piece of the profits or you can't keep practicing here, or, pay us for providing management, pay us 30% of your collections and we'll provide management to your practice. Those are things that make worse case goes. I've not studied or been involved in the case in Florida, but interesting about it is that the Florida Society of Anesthesia is the relator or plaintiff in that, suing on behalf of the government, and it ties into the anesthesia industry or association. It may very well be that it's a turf battle between anesthesiologists and the state association against the surgery centers and GI facilities and so forth. But regardless of what it is and whether it's a turf battle, it still means that somebody's going to be spending hundreds of thousands to millions on legal fees trying to defend it, and then hope that they win whatever they defend. So sale of shares, anesthesia cases, another fascinating area that's been well reported, and it's sort of gotten tighter and tighter and tougher over the last couple of years, is out-of-network cases where a center's operating out-of-network and a payer essentially makes a claim one way or another that they're getting overcharged or that they're undercharging the patient, the beneficiary, and thus what's been paid by the payer is improper. Recent verdict in this case was against a chain of centers, but something like $37 million, and just indicates sort of the increased amount of enforcement and aggression by the payers in looking at out-of-network behavior. And you're seeing at large levels where you think maybe people have been too aggressive about it, but you're also seeing it at the individual center level where payers are increasingly aggressive about it and looking at it a way to recoup monies. So again, 6 to 7 types of core cases we see: redemptions of shares, non-competes, sale of shares, false claims cases relating to some of these areas, the anesthesia, the out-of-network, and so forth. And then also, of course, all centers have the run-of-the-mill labor and employment cases and other kinds of cases. Here, the focus is on things that are really very specific to surgery centers and to an extent to healthcare. In terms of overriding advice that we give to people on the front end on cases, and partly then, Jeff really runs these cases on the national level, and we're everywhere from Alaska to Oklahoma to the rest of the country. One of my great pleasures is seeing him fly up to Alaska in the middle of the winter, but a terrific lawyer in these things. The core pieces of advice that we have, 7 pieces of advice just quickly is, first thing is when you get a complaint of any shape, sort of form, whether it's verbal, whether it's written, whatever it is, it's understanding your case. You have to do an internal review, attorney-client privilege, to understand where your exposure is, what's going on, what the situation is, because you can't really respond to anything going forward without really knowing it. When you talk to your lawyers, you have to, with your lawyers, bring out the bad stuff. The lawyers are famous for 3 years before a case going to trial telling you, oh, you got a great case, and as you get closer and closer, being more and more tentative about your case. But the more you bring out all the bad facts you know early on, the better sense you get of the reality of your case, and whether it's a good case, bad case, how much you should worry, how much you should worry about settling, and stuff like that. The second concept is document your actions on the front end, all the way through document your actions. Some of the worst cases happen where people really didn't document their actions and try and allege a reason for either redeeming somebody or some other thing after the fact or late in the game. Then it doesn't carry the same weight as it would if somebody had documented all the way through. Obviously, many of you have heard this all the way through the years on employee issues. It's the same on all these other kinds of issues. If you're doing a valuation for the sale of shares, you want to document the valuation. If you're choosing not to do a full valuation, well, you want a very strong valuation backup or support for how you got to the price you got for the sale of shares. If you're choosing to change anesthesia providers, you don't want it to look like you're extorting it, an anesthesia group. You want to be very clear that you're doing it because they're either not staying for the recovery of the patients, they're charging your patients out of network, whatever the reason is for your change, that you've documented it clearly. If your reason for doing something is an improper reason, well, you shouldn't be doing it. Third core piece of advice is don't panic. Some of the worst outcomes we've seen throughout any of these areas and cases are people where they've got to request information, they panic and change or adjust records, and instead of having a bad outcome, they've often turned it into an absolutely horrible outcome. So don't panic. Fourth thing is, like the TV show, call your lawyer right away. You want your discussions to be attorney-client privileged. Be careful how you communicate to the other side. I mean, so many things should be common sense, but they're counterintuitive. I mean, you often want to tell an employee who complains, we're so sorry about this, we feel bad you feel this way, whatever it is, but, sometimes then the employee's lawyer turns that into an admission that you did something wrong. So unfortunately, in today's litigious world, you want to have counsel involved early, and if you're doing internal investigations, internal reviews, you very much want to have them done on attorney-client privilege. Fifth item is follow your bylaws, your operating agreement, your policies, your handbook. Your employee handbook says you can give somebody this amount of leave or this amount of that. You want to follow it directly, and Tom will talk about that more in your in the issue of medical staff and privileges and so forth. Sixth item is litigation's unfortunate. You have to do 2 contradictory things. You want to be very aggressive against the other side, and you also want to always understand your settlement opportunity. So you got to be aggressive so that the other person knows they can't take advantage of you, they can't try and extort you. At the same time, if your litigation costs are going to be X and you can settle for less than X, you want to always be at least considering what settlement would look like. And people hate to hear that. They hate to back down to somebody who's suing them, extorting them, etc. Our litigators hate to talk about it because they don't like the fact that somehow or another they seem weaker because they're actually talking about settlement. But as a business person, as a business center, it's being very aggressive against the other side, but also always understanding what settlement might look like. The last issue I'll talk about right now is on the sale of shares. It's either getting valuations or having very, very good backup as to how you're valuing shares for sale. let me turn it over to Jeff so I don't take any more of his and Tom's time on litigation for surgery centers and Tom on peer review and so forth. Thank you.
Hey, thanks, Scott. And what I want to do is talk about, and try not to rehash some of Scott's general advice, but jump into two of the bigger areas where we see a lot of surgery center litigation, and those are the redemption disputes and the non-compete disputes that Scott both mentioned. I want to talk about them, kind of what the typical scenarios we see, the types of attacks we see in those cases, and from a litigation avoidance standpoint, your best way to try to avoid, put yourself in the best position if you are actually in that litigation, or avoid it altogether. On redemption cases, your typical scenario is, under the operating agreement, there's some sort of triggering event or option of the surgery center to actually buy out, one of the members, one of the owners. It could be a loss of privileges by a physician owner. It could be a breach of safe harbor type 1/3 test. Could be another breach of the operating agreement. Some operating agreements allow for redemption without cause. And there's typically a vote, there's the redemption, the physician, and for one of the reasons, or the redeemed owner, and for one of the reasons that Scott mentioned early on, these are often some of the best investments that the physicians have ever made, doesn't like the fact that they're being redeemed for obvious reasons and file suit. The typical attacks or bases for these suits that we see really fall under three different categories. One is a substantive type attack on the reason for the redemption itself. That perhaps they would argue that the operating agreement triggering event wasn't truly triggered here. They may quibble about the language of the operating agreement. They may factually contest whether or not they actually triggered, breached the contract, breached the 1/3 test, whatever the real reason was that caused the triggering event. The second type of attack is really a procedural type attack, and this is usually combined with the substantive type attack, but they say that even if there was a triggering event that allowed the redemption, then there were certain procedural hurdles that the center didn't follow that they had to do. Did they give proper notice? Did they vote on it properly? And jump through any of the other procedural hoops that is provided for under the operating agreement for the center to take action and actually redeem someone? Were they paid the proper amount? That's another challenge. The third category, and the one that I'll spend a bit more time on than these other two, is what we've seen as a trend more and more of, and that's attacks on redemptions based on public policy or regulatory issues that it's argued voids or prevents the redemption. And these attacks have become more and more sophisticated. While the first two attacks, the substantive and the procedural, are really issues that we've seen for years, and they're really basic contractual or breach of contract type issues. You can really try to put yourself in best position to avoid those by consulting an attorney when you're thinking about the redemption, consulting an attorney before acting, and as you go through those procedural steps of giving notice, taking a vote, and doing everything else you're required to do on the operating agreement at the outset. That puts you, then you're going to put yourself in your best position rather than just trying to, take a look at the operating agreement yourself and go through it. Involve an attorney early, get them involved, ask their opinions, get their guidance on what should we do, what should we not do in terms of effectuating the redemption. On the public policy aspect of it, now the types of attacks and the premise for these types of attacks is that the redemption was really for an illegal reason. That even if you had, let's say, the ability to redeem, the triggering event was without cause. The argument is that even though that's what the center says it's doing, the real reason was for an illegal motive, an improper motive in retaliation, for example, not bringing enough cases to the center. And so they make an argument under public policy saying that even if you follow the language of the operating agreement to a T, the redemption should not be allowed and was wrongful because there was really an improper motive behind it. A corollary to that is if it's for the the redemption was for failing to comply with the safe harbor type 1/3 test in the operating agreement, it was invalid because that test really doesn't apply because the center may not have been totally safe harbor compliant. And we'll talk a little bit more about that in a second. But these types of attacks are a little different than the procedural and the substantive attacks that we've seen, and really are typical breach of contract type attacks because they focus on motive. They're akin to an employment discrimination case where an employer fires someone for substantive reasons or without cause, but the allegation by the fired employee is that it was really for an improper discriminatory motive. So these cases are different. When the motive is at issue, these cases really turn into what's akin to a forensic examination of the center's history with regards to their motivation about how they deal with referrals of cases, volumes of cases, things like that. And it's for this reason that whether you're in the middle of redeeming someone, whether you're thinking about redeeming someone, or whether you may in the future actually redeem someone, it's important to have get your center's house in order and be very vigilant and cautious in terms of how you handle discussions about this. In these types of cases, through the discovery process, when the attorneys exchange information and documents and you look into the center's history, they look at who else was redeemed. Has there been a history of redeeming people that are not large producers but rather smaller producers? They look through documents, emails, about whether or not there's been a lot of discussion about encouraging referrals or being punitive against folks that aren't referring enough cases or doing enough cases at the center. They look at, and there'll be depositions of key members of the surgery center, and they'll be asked, have there been comments made at board meetings or in the hallways or anywhere about a particular member not being a good owner because they're not doing enough cases at the center. And in this, and we all know that physician owners, surgeons, are cut to the chase guys, and they're bottom line folks. And so oftentimes they may make, offhand comments about that. It's, whether if you're an administrator, if you're a fellow owner and manager of the center, it's important to really be vigilant about not allowing those types of comments, certainly not putting those types of comments and too much in writing, not necessarily tracking high producers and low producers, because you think of it from the vantage point of what could lead to the insinuation that the true motive here is to get rid of somebody who is not a big producer. How much of a premium does the center place upon, folks that are high-level producers versus low-level producers? So it's important to be vigilant about trying to discourage that type of talk, making sure that the owners, the other investors, even though they may not understand the nuances of the safe harbor, and the Stark and self-referral issues, that they always, avoid talking about folks that, are freeloaders, non-producers, things like that. That type of language will come back and haunt you in these types of motivation-type suits. Another attack we've seen in these types of cases is that where a center has a safe harbor type provision that allows for redemption when you don't comply with a 1/3 test, there's been a more and more sophisticated attacks on that, saying that provision in an operating agreement that where the center is not totally safe harbor compliant for whatever reason, whether there's an institutional investor or for any other reason, then we've seen plaintiffs and individuals attacking redemptions, bringing in nationally known experts to say this type of provision where you're really trying to come in compliance with the safe harbor, but you're actually not in compliance with the safe harbor, the mere existence of this provision is really one that's really based on trying to do the opposite of the safe harbor. It's just trying to encourage referrals. And so trying to redeem someone for not complying with that, they try to attack that and invalidate that provision. And we've combated that type and successfully combated that type of argument by bringing in expert witnesses who are former assistant U.S. attorneys who would actually prosecute claims, whether it be under the False Claims Act or others, but involving Stark and Safe Harbor laws. And they're able to testify that because violation of the Stark and the Safe Harbor Acts are intent-based, anything that shows that folks are trying to be, that a center is trying to become closer to a safe harbor, even though it's not totally safe harbor compliant, is something that's viewed favorably and something that should be, something that wouldn't invalidate that type of provision. In the non-compete context, as Scott mentioned, I think we've seen more of these in the past, but there's still a steady volume of these types of disputes coming up. The typical contexts are, as Scott mentioned, where one of your investors is taking an ownership position in a competing center, where another typical situation is where one of the owners is taking employment with a competitor that may be a hospital. And these types of cases are difficult ones for centers to navigate through and deal with. All non-compete cases, and I've handled them primarily in the healthcare industry, but also outside of the healthcare industry, they are challenging cases. Anytime you want to enforce a non-compete, courts throughout the country are hesitant to enforce non-competes, or in the case law instructs them to take good, hard looks at non-compete cases, because a non-compete is always seen as something that is a prohibition on capitalism to a certain extent. It's a restraint on trade because it's preventing someone from going out and working in some manner or having an ownership interest, in some way making money. So the drafting is, for that reason, drafting is key in your non-competes. Many states have specific language, type of magic language that you have to have in a non-compete for it to be considered enforceable. There may be certain elements you have to have in your non-compete for it to be considered enforceable. And many states also are very specific about what there has to be for a non-compete that impacts physicians or medical care to be enforceable. So it's very, very important to revisit your non-competes, talk to a lawyer who's knowledgeable on them, and make sure, again, similar to having your house in order on the redemption side, have your house in order just in terms of your documentation on the non-compete at the outset. The other thing to think about,
and Emma, you can move the slides forward too. Let's move the slide forward at least one or two.
And the other thing to think about with all non-compete cases is that in order to, when you have a non-compete case, one of the main things you want to do is you want to try to stop the person who's violating the non-compete from enforcing or from competing. So you actually go to court and you try to get some sort of emergency injunctive relief, whether it be a temporary restraining order or a preliminary injunction, to get emergency relief on a quick basis, much quicker than your typical lawsuit, but on an expedited basis to try to prevent the competing. And the courts and judges have broad discretion in entering this type of order. So it's really viewed as an equitable remedy, so they're really allowed to take in multiple circumstances, multiple factors, and so they have a lot of discretion in terms of deciding this. So the story is very, very key in these types of disputes. And when I say the story, I'm talking about why the center wants to enforce it. Did they treat this person fairly? Is it really fair to stop this person from competing? So you want to be in terms of your dealings that lead up to trying to enforce a non-compete. You want to be viewed as reasonable. You want to be viewed as fair, and that goes from not only how you drafted the non-compete, how you treat the person, and how you try to accommodate the person. On the flip side of that, one of the oftentimes clients approach us about someone is going to violate the non-compete. They would like to offer some sort of accommodation, but they're unsure how that will play out, both in this particular case with this individual that's leaving to compete, but also future cases, and it's a fair concern. While you want to be, fair and reasonable and try to accommodate folks, especially in cases where it's not truly going to harm the center but the competition, you have to be careful. You have to look at the law, because what you don't want is a situation where you allow somebody out of a non-compete, you allow multiple people out of a non-compete, and then in the future, you've actually got someone who's going to violate the non-compete, and it's someone that's going to really hurt the center. It's going to harm the center, and all of a sudden you decide to enforce the non-compete, because that's all going to come in front of the judge and also be discoverable in the case. And the question is going to be, why, if your non-compete was so important and so vital to the center, how come you didn't enforce it in all these other cases, you let these other folks violate it, but all of a sudden you're enforcing it here? And that's not a simple answer. So typically we give guidance to clients. We look at the case law and give guidance to clients. If you are going to allow someone out of a non-compete, you have to try to make it as specific as possible to that particular person and those particular circumstances, so that you aren't setting some sort of a precedent that will come back and haunt you in the future when you're looking to enforce the non-compete. That's all the comments I have for now, Scott.
Thank you. We're going to turn to Tom Stallings in a moment. I wanted to encourage people on their computers to, type in any questions they have. Would love to have a chance to answer them. Turn it to Tom Stallings. And Emma, let me ask you to flip a slide forward and just see where we're at on the slides, too. It's great. Tom, let's turn it over to you.
Great. Thanks, everyone.
You can go another slide forward. The slides don't match the presentation, so people just so you have the slide background. But Tom, you go ahead. Thank you.
Thanks. Great. Thanks, Emma. Thanks, Scott. Thanks, Jeff. So I want to talk about medical staff litigation, and I want to do a couple things before turning it back over to Scott for some concluding comments and hopefully some question and answers. First, I want to talk about the types of medical staff litigation matters that we see most often, and there are 5 of them. And secondly, I want to give you some practical advice for ways that you can protect yourself and your organization in medical staff matters. So in terms of the types of cases we see, by far and away the most common is doctors suing for loss of privileges. In each of these instances, I want to give you an example of a real case that illustrates the point. So there's a well-known case out of Texas that involved a doctor who sued when he lost privileges. Now, there appears to be some very serious quality issues, that there was patient death following a procedure, another patient had a stroke following a procedure, there appears to have been a wrong site procedure done. And as a result of these, the doctor lost privileges at the facility, but ended up turning around and suing, saying that the facility did not follow its own bylaws and they acted in bad faith in taking actions against him. The matter went to a jury trial, and the jury awarded the doctor over $300 million in a jury award for this case. Now, the court looked at that and said, well, that's excessive, and reduced it to what the court felt was a more reasonable amount, but that was still $33 million. So huge scare for this facility. Now, they did appeal, and they were able to get that judgment reversed against them on appeal, but they obviously spent tremendous amounts of money defending themselves against this, and probably there's things that they could have done to protect themselves in terms of making sure that every step along the way they had followed their bylaws and were acting consistent with their own written rules. And where there's a deviation between the facility's written rules and what they do in the real world, that's an invitation for litigation. The second category that we see commonly is related, and that's the doctor suing for reporting to either the National Practitioner Data Bank or to the state medical board. That obviously that's typically as a result of some sort of disciplinary action at the facility or other finding of wrongdoing on the part of the doctor. But obviously it's a significant event in the professional career of a physician to get reported to the National Data Bank or to their state board, and some doctors are going to fight about that. So let me tell you about a case that came out of Florida. There was a surgeon who had a fit when his case was going to be delayed for 20 minutes. He smashed a telephone. He flung a medical chart to the ground when the nurse asked him for written authorization to proceed with the surgery. He verbally abused the nurse manager by raising his voice, using profanity, calling her a liar. And my favorite, he threw jelly beans down the hallway. So the facility suspended the doctor because of his behavior and reported this to the National Practitioner Data Bank. The doctor challenged the report, claiming two things. First, it wasn't factually accurate, and secondly, it's not the type of case that should have triggered a report. On the factual accuracy, the doctor claimed, for example, the phone accidentally broke when he tripped over its cord. And he didn't really throw jelly beans down the hallway. He was eating jelly beans, but some of them fell to the floor when he tried to discard the flavors he didn't like. The rule of law is the data bank doesn't act as a fact finder. They don't second guess the findings of the facility. They simply say if the facility reached these findings, should there have been a report? The doctor in this case argued that a report was not appropriate because there was no patient harm, and the court ruled that that is not the determining factor to whether there's a data bank report or not. Actual harm to an individual patient is not a prerequisite. Instead, the court agreed that disruptive and abusive behavior by a physician poses a threat to patient harm because healthcare is a collaborative process, and if other members of the team are reluctant to speak up, raise questions because of the doctor's reaction, that could compromise care. So in that case, the holding was that the report to the data bank was appropriate. Another category that we see is a claim by a patient that the facility was negligent in issuing privileges to the doctor. Case out of Illinois involved a podiatrist who performed a bunionectomy despite the fact that the patient had a diabetic ulcer at the site of the bunion. Diabetic ulcers, as many of you know, are sources of infection, and typically a elective case will be postponed until the ulcer has completely healed. In this case, the podiatrist went ahead with the procedure. There was an infection. The patient's foot was amputated. The patient sued both the podiatrist and the facility, and before the matter went to trial, the podiatrist sued with the patient for about $900,000, but the facility did not settle and went to trial. The finding at the trial was that the facility issued privileges to the podiatrist in violation of its own credentialing standards that included the fact that the podiatrist should have had 12-month podiatric surgical residency and have been board certified, and this doctor had neither. The result was a jury award of almost $8 million against the facility for negligent credentialing. So again, the facility ended up paying about 8 times the amount that the actual surgeon ended up paying because it did not follow its own rules on when to issue privileges to a podiatrist. The next category that we see is cases involving confidentiality. I know you're all familiar with peer review privilege. Peer review privilege is a creation of state law, so it varies from state to state. Case I want to talk about is a case out of Virginia, which involved a television station doing an expose on bad doctors. One of these supposed bad doctors sued the television station for defamation, and the television station subsequently subpoenaed credentials, quality, and peer review files from the facilities where the doctor practiced in an attempt to buttress the television station's claim that this was a bad doctor. The facilities, citing the peer review privilege, refused to comply with the subpoena, and much to their disappointment, the trial court ordered that the facilities needed to turn over the files. The facilities refused. The matter went up on appeal. The state Supreme Court ruled that the records were in fact protected by the peer review privilege and they should not be provided. But it's an illustration that sometimes you need to stand your ground when you know what the rules are and be sure that the confidentiality of your documents are protected. And the last category that we see with some regularity are suits over providing false or misleading information. So a case out of Louisiana involved an anesthesiologist who was fired by his anesthesia group for being impaired on the job. And when they fired him, they sent him a letter saying that you've been found in an impaired condition on several occasions, and that puts patients at significant risk. You are terminated for cause. The doctor, having been fired in Louisiana, went across the country to try to start over, applied for privileges in Washington State. Unfortunately, the anesthesiologist returned to his old practices, and while in Washington State and under the influence of Demerol, prematurely removed a patient's breathing tube, leaving that patient without oxygen and putting that patient in a persistent vegetative state. The patient's family sued the Washington facility where this procedure happened, and the Washington facility in turn sued the Louisiana anesthesia group. And the reason they sued the anesthesia group, again, remembering the anesthesia group had fired this doctor for cause for being impaired, is the anesthesia group wrote a letter of recommendation for this doctor when he applied for privileges in Washington State. The letter said he was an excellent anesthesiologist and that they recommend him highly. I'm sure that the anesthesia group didn't want to invite a lawsuit from the doctor by writing a critical letter of recommendation, but by writing a false and misleading letter saying he's an excellent doctor and that they recommend him highly, they ended up with significant liability. Now, of course, the goal of any credentialing or peer review process is to avoid litigation. Sometimes it can't be avoided, but there are steps that you can take to minimize the risk that your facility will be the subject of litigation. So let me share with you 5 best practices to avoid peer review litigation. First, be proactive. Don't assume that problems will resolve themselves if they're not addressed. It's better to nip things in the bud and deal with them head on early before they snowball out of control. Secondly, you ought to keep your medical staff bylaws up to date. We've talked about a couple situations where facilities didn't follow their own rules and there was a disconnect between their written rules and their practice. And once you've started down a peer review path or once litigation has been initiated, it's probably too late to revise your medical staff bylaws because you generally can't change the rules in the middle of the game. Third, review your medical staff bylaws, policies, and practices to be sure you're maximizing your ability to qualify for your applicable state peer review privilege. Once a document has been created as a non-privileged document, there's no way to go back and make it privileged. The genie's out of the bottle, and that document would be discoverable in litigation. But if you learn the rules that are applicable in your state and follow them consistently, you'll maximize your chance of being able to protect your documents in the event of litigation. Fourth, follow your bylaws. Don't put yourself in a position where you're not complying with your own written rules. And fifth, keep financial issues out of peer review. Peer review activities are supposed to focus on quality, patient care, competence, professional conduct, and they're going to be governed by your medical staff bylaws. Financial issues don't have a place. Financial issues are important in any surgery center, but those are governed by your operating agreement and shouldn't bleed into medical staff decision-making. With that, I'm going to turn it back over to Scott, who I know has some concluding comments, and then hopefully we'll have a few minutes for questions.
Tom, thank you so much. We're just going to go back very quickly, play through a couple of the overriding concepts, and maybe turn back one slide is make sure that I didn't fail to mention a couple of things we wanted to mention in terms of pieces of advice. One of the issues is any kind of malpractice case, and often a lot of different kinds of cases, you want to make sure right away that you do contact your insurance company, because you could do things in the interim before contacting them that could leave the insurance company with the ability to be able to not have to cover it. They'll try and reserve the right to not have to cover it. you want to report to insurance early. And if they've got counsel they want you to use, you probably got to use their counsel on that. I'm just going to touch through a handful of different things very quickly, particularly the ones we've not touched on before. When dealing with the other side, very cautious in admitting any wrongdoing. You know, unfortunately, there's lots of different theoretical concepts on malpractice cases that you avoid malpractice cases if you apologize, you admit early that you made a mistake, et cetera, et cetera. But unfortunately, your insurance company may say that your coverage doesn't count if you've done so. So there's all kinds of good courtesy things you'd like to do with the other side in litigation, but that you can't do, unfortunately. The don't panic concept is you can never destroy documents. Some of the worst cases in the country have come out of document destruction, or gotten a ton worse because of it. Email traffic, very careful in what's said in email and what's said even in texting. People say things in email that they wouldn't say in person. If they get discovered in cases, often could end up being just absolutely, horrible. We've already discussed plenty of this concept of, reaching out to counsel early and internal documentation and trying to do things through the proper peer review and attorney-client privileges. We've discussed those things. And again, concepts of being aggressive and mindful of benefit of cost versus pursuing litigation versus settlement. We always believe you got to have offense too. Nothing good comes out of being solely on defense. The thing that we want people to realize too, when people want to sue somebody else, sue another company, sue somebody else, they also have to realize the other side thinks the same way. So they're going to bring counterclaims too. They're usually not going to roll over. And so you can't really control the cost of litigation just because you're the plaintiff in it. I think we've covered most of the core things we wanted to cover. Let's see if there are any questions. And if not, we'd love people, anytime, call or email Jeff, Tom, myself. You should have our email addresses, numbers are easy enough to get us. And, we'd love to curbside advice for free, quick discussion on stuff. Always happy to do that. And then if you need something more seriously, we've just had this year alone, a handful of redemption cases that are fascinating, some non-compete cases involved in a huge antitrust case related to healthcare and so forth, and also involved in a couple of really interesting, from our perspective, interesting false claims cases. From the client's perspective, I don't think they find them so interesting. But we're seeing, we're intimately involved in false claims cases, antitrust cases, and redemption cases. So always happy to help any way we can, and it's a pleasure, and of course how we make our living too. Let me see if there's a question.
Yeah, Scott, happy to help out here. And as a reminder, you can type in questions by typing them into your control panel in the question in the box labeled Enter Questions for Staff. And Scott, I'm happy to read some of the questions we have coming in so far from our audience.
Yes. Tom, there's a question about something you said about peer review and quality that you led off with when you were just getting started, and you weren't talking that loudly at that point. Could you reiterate what you talked about with quality and peer review? This is Emma, this is how my partners often respond to me. Tom Stallings? We might have lost Tom.
I apologize.
Sorry
I apologize. I was on mute. That was my bad. I will say I'm not entirely sure what the question was about which comment they didn't hear.
Something about something that started with quality and peer review, listed under the peer review section. If you could just talk for a second about peer review, a couple of the core points on it very quickly.
Sure. There are obviously a few key concepts that you always want to keep in mind when you're doing peer review. One is taking advantage of the immunity provisions that are offered by both federal and state law, and you need to be familiar with what you need to do to get the immunity because you want to be able to claim that if you're going to be sued. Also, each state has its own peer review privilege law, which provides confidentiality to your documents, and you want to be sure you're acting in accordance with that wherever possible. so that your documents would be protected. And a lot of that requires efforts to be made on the front end so that you're prepared in the case that you need them, because if your bylaws are out of date or you're acting out of compliance with your bylaws, that's going to be held against you, and it may compromise your ability to claim the immunity and confidentiality protections.
Thank you. There's a question on anesthesia programs, and unfortunately on anesthesia programs, it's easy to outline what's totally legal and what's totally illegal, and then there are a whole number of models that are someplace in the middle. And one of the questions we have has to do with something that's in the middle, and it really will depend on the facts and circumstances of that case. What's easy in anesthesia, legal is clearly the traditional model. Anesthesiologists do their own services, keep their own money, just the old traditional model. Clearly illegal on the far other side is going to the anesthesiologist like you're the mafia and saying, give us a piece of your profits and you could keep your contract. And all kinds of ways, where there can be lesser versions of that are legal, that really make sense. There's a question about, can we bill for the anesthesia services and pay the anesthesiologist? Maybe. If there's good reasons why you're doing it, better managed care contracting, better service provision, being able to oversee the thing, making sure you're in network, there may be facts and circumstances where that's appropriate. Other situations, it can be looked at as a reverse kickback, that the anesthesiologist is giving you the right to bill and that you're just keeping the delta between what you're billing and paying them. And there's at least been allegations that that itself is a reverse kickback, that fact that you're keeping that profitability. And it really could end up, a lot of it depending on facts and circumstances is what drove it. The more that people start with deep spreadsheets that show, if we take the anesthesia revenues away from the anesthesiologist, we're all going to make this much more per partner, and this deep, what we call spreadsheet selling. And the more that you go to the anesthesiologist, you've been keeping your billing. We're now going to bill for you, and we're going to pay you 30% of what we collect, so that you're really just taking that 70% off the top. And if you want to keep your contract, which includes seeing Medicare and Medicaid patients, you have to do this. The more challenging that could be to defend. But it's very, very facts and circumstances dependent as to whether legal or not legal. One of the things that's fascinating in these cases, there's this whole mix of, is it a kickback or is it a turf war between anesthesia providers and ASCs, or is it some mix of both? Interestingly enough, in at least one of the recent cases, the government chose not to join the case. The plaintiff in that case, who brings the case on behalf of the government, is still allowed to bring the case, and they actually get a bigger percentage of the contingency, but the chances of great settlements go down when the government doesn't join it. When the government does join a case that you're a defendant in, it's not that it's game over, but the chances of you having to pay something have gone up dramatically, and the chances of being significant go up dramatically then as well. Let me just see if there's any other questions that we could answer. If they're just CRNAs working under the surgeons in an office setting, probably generally much more traditional and appropriate. If your CRNAs are working with you in an office, and again, I can't answer the question fully and don't someone rely on it, because ultimately you got to look at billing and coding regulations, look at the specific deal, look at specific cases. But traditionally, surgery centers have often employed CRNAs, and at least until some of these recent different cases, not been a big issue. And also in your own office, employing CRNAs and paying them a percentage of productivity, again, absent something unusual, is not that far from what's been a pretty recognized or thought of as an okay way to handle business. So again, I don't want anybody to rely on that as legal advice, because everything's so dependent on facts and circumstances. I'm talking generically or generally, but hopefully that's helpful. Let me see if there's anybody else that's got questions. I know we've had a couple questions so far come in. There's another question that says, what if, sorry, and I'm not sure that's where the question ends, and I'm not sure if they mean, what if Donald Trump wins the presidency? What if Hillary Clinton wins the presidency? I just don't know where the question was going. No, I say that facetiously in a nonpartisan way. Anyways, we appreciate, Emma, your help in quarterbacking this, and then Tom Stallings, Jeff Clark. Tom is 804. Tom's phone number, 804-775-1007. Tom Stallings. And Jeff Clark is 312-750-8636. And feel free to reach out to any of us anytime. Happy to have an initial conversation and just figure out what you have going on, if we could be of help, and then of course, love to help. Anyways, thank you all very, very much. And if anybody thinks to, a quick email, sbecker@McGuire-Woods or sbecker@Becker's Healthcare, just to let us know, did you like this, not like it, useful, not useful. It's always helpful for us, if for no other reason, to tell us we should stop because we're giving people a headache, or keep doing them. So please feel free to email me. We always appreciate it greatly, any comments on this. Thank you very, very much. Emma, thank you.
Great. Thanks so much, Tom, Jeff, Scott, and this concludes today's webinar. Have a wonderful afternoon.